The other thing we had to work with is that because we were also trying that case, not simply appellate counsel, our lawyer stood up and said, Your Honor, we are requesting that you give a curative instruction, that you didn't mean to be commenting on the credibility of the witness, that the credibility of the witness is entirely for the jury to assess. And if anything, the court has said that suggests that the court found this witness incredible, that's certainly not what was intended. And they didn't want to ask for that because they didn't want the problem cured. We wanted the problem cured because the trial was going splendidly. So curative instructions, to answer another part of your question, are broadly presumed in Georgia to be effective. And when we argued the Williams case, when I argued that, one of the things I pointed out is if you don't require a contemporaneous objection, there is no opportunity to cure. And this court has 4 times in the last 12 months in felony criminal cases said that curative instructions are presumed to remedy any prejudice. In serious misstatements of the law by prosecutors, things a lot more serious than a civil case over damages.
That's interesting. Jeff, I don't know the rule on that. Is there a similar presumption in California?
I've never come across it, but I've never actually litigated the issue of curative instructions or admonitions before.
Yeah, my own hunch is that the curative instructions probably don't do a heck of a lot. But on the other hand, I have interviewed jurors who have mentioned that, well, yeah, such and such was said, but the judge told us not to consider that, and so they do at least make an effort. At least some of them do. But there is the toothpaste out of the tube factor.
Right.
So that the persuasive effect has already been made. How do you talk yourself out of being persuaded by something?